Hi, welcome back. This is chapter 2 in our cadastral mapping book that we have here. We're going to continue on. Last time we talked about the Utah Code, went through a lot of important information. Hopefully you were able to finish the homework and get some of that done. If you still have questions about that, you can continue to review the video, ask questions as we meet on the web, things like that. Today we're going to talk a little bit about the fundamentals of searching land records. Oftentimes, as cadastral mappers, we may need to determine proper ownership or boundaries based on the records, and so in order to do that, you need to be able to search those records. So we're going to go over some of those basic principles and give you some steps on how to do that. And then we'll have some homework again at the end, and we'll go from there. So, county recorders are responsible to the county legislative body for accurate identification and portrayal of all the parcel boundaries and description for use in valuation and taxation of the parcels for the county's portion of the annual real property taxes. So that's our responsibility. There's a definition of cadaster, which is the root word of cadastral mapper, which is what we're all trying to become certified in. It's defined by the American Heritage Dictionary, the second edition, as a public record, survey, or map of the value, extent, and ownership of the land as a basis of taxation. So cadastral mapping is crucial to accurate reporting and portrayal of boundaries and descriptions, which in turn constitutes the basis for area calculation, including square footage and acreage, upon which the valuation is made for taxation purposes. Cadastral mappers must be able to determine the location of lawful boundaries as established and determined by the official records in the county recorder's office, and have the skills necessary to be able to draw the boundaries of those parcels. So in order to accurately identify the owners of the title of process by its boundaries, the cadastral mapper must be able to search all of the records in the recorder's office in order to determine who the lawful record of owner of the fee simple title is. A cadastral mapper must also be able to sufficiently skilled to be able to identify any conflicts between the property boundaries, including overlapping, underlapping, or gaps of those parcel descriptions. So some of the resources available to the county recorders include some of the duties of the recorders, the records, the indexes found in the Utah Code that we've been talking about in Title 17, 2116. It talks about all the different indexes that we need to keep, and which gives the searchers multiple options in order to find their searches. So many counties maintain an index of parcel ownership genealogy that lists the succession of title owners for each parcel by deeds or other conveyances, without the other extraneous entries of the record. And those are called the deed index files, and that's a common nomenclature for that particular resource. Okay, let's start talking about some of the fundamental principles of title searching. So we're going to highlight some certain basic fundamentals common to all the searches made in the public records in order to determine real property ownership. We're going to go through some of those basics, and because not every county is the same and one size doesn't fit all, there's going to be different occasions in which instances and title searching might be different, but they all have the same common principles. And so we're going to talk about some of those common principles. The first principle is that the records are all public. In all of our counties, the records in the recorder's office are all public, and that's based on the Utah Code. It's in 1721-3 and also 1721-19. So the inspection of the records, because they're public records, it's also required by law that we make them available for public inspection. So they wouldn't really be public if you couldn't be able to inspect them and make copies of them, and other things, with only a few exceptions of those that are protected or controlled by privacy statutes and laws. There's indexes to the records. Okay, that's a fundamental principle. All of us have indexes to the records. They're actually required by law to be kept and to be made available for public inspection and use. And the other resources in the recorder's office, such as the tax plats, are generally considered to be a work product, and they're not. Those are not required by statute to be certified as records, even though some counties may provide certification of the records. But so some records, such as deeds and things like that, they are required to be certifiable, and some are not. But you can oftentimes people request those, and so. But the indexes are generated as a record, and so therefore those are not usually considered a work product, even though they're used by the county, by the public, and by county officials. Those are not official records; they're just the work product. There's a term or a principle, genealogy. So just like we as families, we have genealogy. We know who our ancestors are, or can trace our ancestors and things like that. Parcels also have a genealogy, and oftentimes they're referred to as a chain of title, a pedigree that begins at the first instance of the transfer of conveyance from the originating governing authority. So oftentimes it's the United States of America, or the state of Utah, or other agencies from the federal government. But the chain of title starts with that first original patent, and it concludes with the current record of owner. So all property parcels have a unique defined description. So all parcel descriptions contained within the records of the county recorder are taken from official, duly recorded documents or instruments of conveyance, or as created by dedicated and recorded subdivision or townsite plats, or they may be created for the purpose of taxation by the county personnel. As in the case of remainder parcels following a division or a split of parcel of a parent. So each parcel has a description unique to the parcel, and no two parcels within the county will have identical parcel descriptions. They all have to be unique, and they also must be written so to be traceable on the ground. In addition to having a unique description, the parcels also have a unique tracking number, and that's usually called a tax parcel number. It's some sort of identifying designator which distinguishes it from any other parcel in the county records. So it might be an alpha or numeric set, or a combination of both, depending on the numbering system that you have in your county. So I know of several different kinds of parcel numbers from various different counties, and yours are probably different than mine. There's also another fundamental principle that each county has a county recorder. So the county recorder is the duly elected official who is charged to protect the records as their custodian. So he or she is charged in making all the county records available to the public for inspection and copying, with a few exceptions. So office practices may vary between the counties, but local conditions prevail as to how and where the public may search and copy those official records. So those are some of the fundamental principles. Let's move on and talk about some of the practical applications. So we're just going to go through the list here. Records. Okay, the larger portion of the records in the county recorder's offices are typically found in bound volumes, and they might be inside a protective vault, or in the basement, or some area that's under control and protection of the county recorder. But as technology has advanced and things have gotten better, there's more recent records may be found in the electronic form, in computer folders, files, and index, and each county is a little different, so they'll be slightly different, but a lot of them, if not all of them, have that electronic format. So because the records are considered permanent, those records that we talked about in the vault that have that are bound in volume, oftentimes there's rules that apply, like the use of pens, markers, highlighters, things like that, or other permanent annotation tools should be restricted or outlawed. In my county, they're not allowed to be in the vault at all. I don't care if they're out in the other area where the computers are, but in the vault they're strictly pencils only, because I don't want anything to happen to the record. If a pen breaks, it leaks ink all over. If a pencil breaks, nothing happens. So in my county and in many of the counties, pencils are the recommended and preferred writing instrument. That's one of my biggest things that I try to do to protect the records, and people forget, but that's there to protect the records so that anyone else in the future can go back and view those same records without them being destroyed. So copies of records, there is an expense to produce those copies of the records, and those requesting copies should be prepared to pay for them anytime they're made. So, and costs vary between the different counties, but paying for copies is something that's allowed by Utah Code 1721 18.5, and a lot of those fees are set up based on your local commission and things. Office hours. Some office hours vary a little bit, but the business office or the business hours for the offices of the county recorder are established by the county's legislative body. So the commissioners or council members usually set those up. And there should be no expectation from title companies or people who frequent the office for special privilege in going further than those posted hours and those things. So sometimes they may ask for those, but they shouldn't be expected to have those extra privileges. That's why we have the posted hours. So one of the applications that we as recorders have talked about quite a bit is legal advice, and what we can and can't say, what things can we tell the public, what can we tell people that come in here. But this is good advice when giving legal advice, is that all county officers and employees should refrain from offering legal advice to the public, and should such advice be required, it should be obtained from a competent legal counsel. And oftentimes I refer them to a lawyer or whoever they might need to give them that competent legal counsel. Also, some of the applications that the recorder's office has, there's many searching tools, things like that, but anything that's in addition to the records that we have, so supplies necessary for a title search should be provided by the individual trying to do their search. for their personal use, and it shouldn't be expected that it should come from county resources. Some of those things like notepads, pencils, scales, drafting tools, all of those, the people should come in with them. It's not really fair for the taxpayers to be expected to pay for everyone else's title search and drafting tools and things like that. So there's a couple of different methods. So now that we've gone over some of those principles, there's a couple of different methods that we use in searching. And search methods vary between title professionals and even county officials who search the records. And a lot of it is determined based on your preference, your circumstances, or the need to find the records. And so how you search might change. But pay attention to some of this methodology because some of these methods might come up later or in the test. But we're going to go through some of them here. There's 5 different methods or type of searches. So the first one here is a name search. So if you're searching, this is a search that's conducted using the grantor or grantee's names as a search criteria, and it may include a mortgagee or mortgagor names as well. But that usually happens if you're looking for a particular person in order to trace the title, or you want to find out where a particular person owned property. You might do a name search. So a tract or a parcel search, these are searches conducted using the property descriptions as the basis for the search. That's the type of search that we're going to do for our homework coming up at the end. There is a document type search. So, and a document searches, those type of searches are based on the instrument type or the document type, such as rights of way, easements, a deed type, a court decree, power of attorney, etc. Oftentimes these are used when trying to find easements. They want to find if there's an easement or if there's a lien on the property. That's a common search. And so those you're looking for certain types of documents and can exclude others. A date and time search. So those are dates. Those searches are based on an approximate time of when a transaction may have occurred. Somebody comes in and says, my grandfather owned this property. This is where it was, but I need to know when he purchased it and when he sold it. We think it was about this time based on genealogy or history or records that they have. And so those you can go do by date and time searches. The last type of search is a deed index file search. And that search utilizes the deed index file. So it's the information contained in the conveyances of record. Oftentimes that may be a tax card or something where it's just those conveying documents that are separated out from all the rest of the documents. There's a note here that a simple deed index file search does not include a search of a parcel abstract, but may identify all the complexities of the title through the abstract search that may reveal. So sometimes in the process of doing research for a particular item or for multiple items in your cadastral mappers, you may have to do multiple variations of these searches, and that's okay to start one way and switch to a different type in order to make sure you didn't miss any information or pick anything up. And we'll talk about that later a little bit, but it's actually important sometimes to check multiple avenues to make sure that you've picked up all of the available information and that there wasn't anything missing from a particular type of index. So let's talk about how we're actually going to do a search. So, and there's steps involved in this process and how we're going to go through it. So the steps for searching the title are generally universal for all people who would be doing a search of the public records for information about individual parcels of real property, regardless of the purpose. So a title company may search different from how a county employee or a cadastral mapper might do a search. And we'll talk a little bit about those differences. But the title professionals, they use specific methods that are most efficient for their particular role that they're doing, which typically involves an ownership and risk identification or risk mitigation or assumption that's typical in any insurance type of business. So they're in the business of insuring property title for the benefit of the purchaser or the lender or someone else. But that's what their business is to insure the title. So title insurance companies sometimes find it acceptable that they would allow or overlook something or assume the risk. It might be a thing. And they assume those for certain title defects or deficiencies. In other cases, they may choose to take exception to them rather than cover them in their insurance. But under those circumstances, the title deficiency or the defect may end up not being cured through the sale or the loan process because of that exception, and so therefore that discrepancy may remain and actually create a burden on the title for an extended period of time, even indefinitely in some cases. And that's something that's different than what we do. If we find some of those discrepancies, we may want to be able to clean up those things, and that's our purpose, is to kind of help perfect the record. So the county's interest is typically limited to making sure that there's the true owner of the title receives the annual tax assessment notices, and that the property he or she is taxed on is accurately identified and described. So we also make sure that a property is not taxed more than once. So oftentimes that's called double tax. We want to make sure that we're not taxing two different individuals or the same person twice. Now we're going to talk about the steps in the processes. And there's 6 steps in this process. And some of those steps are going to be longer than others. Some of those are quicker. We may talk about some for a lot more than others. That doesn't mean that that one is less important or not. Sometimes it's just easier explained. But we're going to go through those steps in performing the title search. So step 1 is to simply identify which property you're going to do the search on. So you locate the parcel on the current county ownership plats, the property description, and it may describe multiple smaller tracts created over time, or splits from a larger parcel, or maybe currently a larger parcel resulting from a combination of smaller parcels which have come together. But you need to identify which property that you're going to do your overall search on. So that's step 1. Step 2 is to identify the purpose. So in order to optimize the efforts and minimize minimize problems and maximize your efficiency in the search, it's important to determine the purpose for the search and define some of the things like scope and its limits. So some of the typical purposes would be to resolve boundary issues or disputes, to discover easements or other encumbrances that may be on the property, to determine the ownership for taxation purposes, And oftentimes people come in and ask for your help to do a genealogical or historical research. And those patrons will come in and we can help them to start some of that information to find that search. But those are the typical purposes. So the scope, in order to determine the scope, you have to ask some questions. So does the search need to be conducted from the beginning of time, all the way back to when the county was first created, or the patent or grant deed, or are there time parameters for that search? Do you only have to go back to a certain person or a certain time period? And so some of those are there. So an example might be to search the records from May 1st, 1927 through January 1946, because that's the issue you might have interest in that time frame. So the second question you might ask is the search defined by parties? So are we only looking for a time when John Doe received the property and when he gave it to James Rowe? Examples like that. Is the research for specific kinds of instruments? Are we only searching for easements during this particular time period, from the beginning to the present, or things like that? The other question is, you could be doing a search for a combination of any of the above. So an example of that are what easements are in favor of the power company that were recorded in the tract between January 1st of 1918 and December 31st of 1941. So that kind of combines a lot of them, but it helps define exactly what you're trying to do and set some of those search parameters there. The last question is, does the scope of the search include an examination of those documents, and are copies required, or is just knowing the information enough? So some of those will help us understand our whole overall goal for the search. Step 3 is to create that chain of title. Okay, so a chain of title is the series of conveyance documents that are discovered in a search that should create a chain or a link between owners through a series of purchases and sale transactions. Okay, so just like a link in a chain, if you think about it, one link, you have your next link and you move on down the chain, and each link actually intertwines the two links next to it. So similar to that, there's an example. If party A, and it's here in your book, party A grants to party B, then party B grants to party C grants to party D, and that creates a chain. So how party D owns it and party A started out with it, and when and where they transferred the property through those different people to finally end up with party D. So the Cadastral Mapper uses multiple resources contained in the Recorder's Office to do the title searching, including current ownership maps, other maps, tract indexes. Abstract is oftentimes what those are called. Deed indexes, card indexes, file indexes, the aperture cards, or any other type of indexes that you might have on record. So all of those are available for use to do your search. So for title companies or professionals, they'll have what's called a chain sheet or a drain sheet, and a chain sheet, which I give you an example of in your homework. It can be as simple as just a lined paper, or it can be a formal page that helps you annotate different things that you're specifically looking for. But a change sheet is basically a notation that charts the history of the ownership and other interests in the parcel. As documents are discovered, searchers will annotate the index information that's found in the abstract. So they may write down the book and page information, the instrument type, the entry number, the date of recording, the grantor and the grantees that are involved in the transaction, and any other pertinent information that you may want to write down. So in that chain of title, fee simple is usually the type of conveyance that is expected. However, sometimes there may be a conveyance that's lesser or a smaller portion of those estates that can be conveyed as well, a percentage or things like that. But for taxation purposes, anything that's fragmented or a split title is inconsequential as long as someone gets a tax notice and they receive that and they pay those notices. So interest in the estates may also be encumbered with obligations to other parties that are not on title. And some of those include unresolved mortgage interests, rights of way, easements, subsurface mineral rights, air rights. All sorts of those rights can be discovered by doing a title search and may impact the value for taxation purposes. Here's a note that deeds don't always come to the recorder's office in a logical or chronological function sequence. So searchers have to account for that if those conveyancers are made in out of order. Sometimes someone may forget to record something and then may record it later in order to kind of fix that chain or link and to make those lawful transfers of title actually take place. So there's two terms to remember. And that's after acquired title. We talked a little bit about that, and prior acquired title. And each of those depend on the type of conveyance document or instrument that was used, and the order in which they're signed, sealed, and delivered and recorded. So also delivery is an important part of making a document acceptable and making a lawful transfer. So there is a caution that I want to caution you. An exchange of a quitclaim deed and warranty deed does not always accomplish a lawful conveyance. So we need to be careful of that. There may be errors with it. There may be other issues involved with it. With a quitclaim deed, doesn't act the same as a warranty deed, so there may be interest in that. I can quitclaim my neighbor's property to anybody I want, but that doesn't mean I had permission or any, I didn't have any right to do that. The document would still be on title, but no conveyance is actually made. So it seems silly. Why would we actually convey our neighbor's property when we don't own it? I don't know, but it happens occasionally. Or it's to clean up the record or something like that. So abstract or tract indexes are commonly arranged by the property site location, and in the case of meets and bounds description, they're usually set up based on the township and range, then by the section in that township and range, and further down to the quarter section within the section. An example is the northeast quarter of section 4, township 4 north, range 2 west. Just an example of how they might be organized. So another way they could be organized is by town site. Most of the counties in Utah have town sites. that are divided up into plats or tracts, and might be further divided into blocks and even down into lots. But those abstracts might be organized by that same method, by township, then town site, then plat, tract, block, and then by lot. So an example of that would be Lot 2, Block 4, Plat A, Farmington Town Site Survey. So abstracts can also be kept in separate things, and for subdivisions, condominiums, PUDs, etc. And they're likely arranged alphabetically within those abstract books, and indexed in the abstract by lot or unit number, or in some cases timeshares might be recorded by time period. And there's a couple examples. Something to note is that oftentimes as we're going through the record, before a subdivision was created, the abstract for that piece of ground where the subdivision sits will be in the section, township, and range of that area. And then once the subdivision and that subdivision plat will appear in the record of that section abstract, and it'll also appear as the first document of the index based on that subdivision. So that'll be that first document. It'll appear in both records, kind of connect them together. And so sometimes there might be some reconveyances or other similar documents that would appear using that section, township, and range legal description. So it's good to check a little bit further past, oftentimes, to make sure you haven't missed anything or they haven't used an old description, and therefore it's abstracted in the other, or it's indexed in the other index file. But usually those carry forward once the subdivision is established and they're using that description. It'll switch over from that section, township, and range index to the subdivision index, and that's a common practice when a new subdivision comes in at some point in the record. So all tract indexes contain a reference to where the document is. So on that, it'll tell us where in our vault or where we can find a copy of that transaction, so that we can examine that and find out if it was a proper conveyance. And it'll also show, the index will also show the type of instrument, the grantor and grantee, or the parties involved. It'll give the date that the instrument was signed, or oftentimes that's called the date of execution. It'll give the date the document was recorded. It'll give the entry number, the recording fee, the consideration amount, and it'll give a brief legal description of the property that's there. So a tract index or abstract books contain a list of recorded documents in chronological order that they were received and indexed according to their location. So not necessarily based on where they're at, but in that chronological order, instead of just pure alphabetical order. So historically, the tract index entries begin with documents filed at the date of the beginning of the official record-keeping time period in each county, and in Utah, often that's around the start of the 19th century, and they run chronologically to the point where in most counties that the book from the index switches over to a computerized index and begins, and there's typically a little bit of overlap between that index on the books and the computerized index. But depending on the scope of the search, both the books and the computer system may be needed to find what it is you're looking for in that history. To do a full chain of title, you would have to go all the way back and do all the books and all of the the stuff on the computer do a full chain of title. So after for computer indexes and searching, the computers are set up a little bit differently than the books are, because of the technology involved. The search in the abstract or the books, the searcher is able to continue to search on the computer system, and those computer systems might vary from county to county, and so the process to find them is a little bit different, but those computer searches can be sorted or sifted out, and so oftentimes the computer searches are much easier to find the specific information that you're looking for. But they also require something a little different, because those computer systems require oftentimes an access code, for lack of a better term. We're going to call it an access code, because the individual indexes on the computer require this access code, which is also a parcel number, because that's what they are. But in order to find them, you need to know that parcel number and do that. And so in some counties, the access to the information on their computer requires that parcel number, or their Sidwell number, the APN, the tax number, the account number, parcel ID number, whatever you want to use, but it requires some sort of information to know beforehand in order to do that search. So that's one difference that the computer might have versus the other tracked indexes. But as you go through the computer abstract, the procedure is basically the same as the other outline. It's also typical among counties by practice and adherence to the Utah State Tax Administration standards that each parcel of land within the county is given and identified and recognized by a unique parcel number, usually in the form of a tax serial number, which is applicable only to a single parcel description and a distinct described footprint. So when that description changes and the acreage or configuration or any other changes, one can expect to see a change in that parcel number as well. A new parcel number would be assigned, and the former one is deactivated, disabled, or deleted from the inventory of the available parcel numbers. That method varies a little bit between different counties, and it may not be the same practice, but you have to remember that we're investigating the actual ground, the property, the dirt, not the individual tax ID number. Even though that might be a key, it's the ground that you're actually searching for. As a footnote to that, by the way, that comes from the Utah State Tax Commission, their standards of practice. So it's not a requirement, but it is their standards. As a footnote, the meets and bounds description, they occasionally might be improved on by survey descriptions or other things that may alter the description. But if it doesn't change its footprint or acreage, then in those cases the parcel described matches the description of record, and no new tax serial number is required. So I tell my folks that if it doesn't change size, shape, or anything like that, then we can usually keep the same description, even though they might use a new or an updated legal description to describe the same piece of property. You can start from different corners, but as long as it describes the same piece, we don't usually assign a new parcel number. Okay, so we're getting close to the end here, but there's something we've talked a little bit about assigning parcel numbers and doing that, and so there's some really important terms that you need to know. If you don't understand these terms already, you should learn them. They're important. They'll be good for you to understand those terms. They might show up on the test, but even just for your general practice, it's good to know these terms as you talk about different things. So a parent parcel. Some of you may have heard that term, but a parent parcel is an original parcel described as it existed before a split, division, subdivision, or combination that created a change in the parcel boundaries. Okay, that's a parent parcel, how it existed prior to the split. A child parcel. Okay, so a child parcel is a parcel created when the original parcel is split, divided, or otherwise changed, resulting in a different number of parcels than there were previously. Okay, so they call those parent and child because the parent is how it was prior, and it becomes two or more new parcels, and so those are considered the children. Okay. Oftentimes, like we spoke, the parent parcel, when there's created a new parcel, the parent parcel are often the ones that become inactivated, deleted, or no longer used. Okay, so the third definition that you need to understand is a remainder parcel. Okay, so the remainder parcel is the leftover portion of an original parcel that was not included in or described as part of the split, division, or subdivision of that parcel. Okay? It could also be described as that parcel remaining in the grantor's name after the original parcel is split and part is conveyed to another party. Okay? Two very similar definitions for a remainder parcel. Okay, those three terms are used all the time in the recorder's office. I would be very surprised if you haven't seen them or heard them in your dealings. But like I was saying, it's recommended that a new tax number is assigned to the child or the offspring from the parent parcel, and that a remainder parcel also be assigned a new tax serial number. So old numbers undergoing any of the above process should be deleted from the inventory, or sometimes turned inactivated, killed, deleted, any of those terms. But basically those terms mean the same thing, that the number is no longer used as a viable tax number, and also it shouldn't ever be reassigned to a different parcel, because it will always refer to that specific parcel as it was with that description, and because that no longer exists, the number shouldn't ever be used again either. So those inactive or deleted numbers and their legal description and abstracts are often kept available for research. Sometimes they're pushed forward, that history is pushed forward to the children. Sometimes you have to go find the parent parcel and do that search on those inactive or deleted parcels, but those are often kept on the computer in the counties. But the searcher needs to be aware that the changes in the tax serial number do occur, and that when those changes happen, the searchers have to follow that piece of ground, that dirt that they're looking for, regardless of its tax serial number, whether it's a new number, an old number, whatever. So a lot of those issues come up, like we mentioned, when a reconveyance happens after a split. They reconvey the old property. It could be their trust deeds, other things. When they're renumbered, they'll use that old description. So some things to be aware of. So back to our steps in our process. So we've talked about that was a very big step that we talked about. Step 3, creating the chain of title. That's a big one where we write down all the documents. We've talked about step 2, which was the purpose, and step 1, which is identifying the property. But we're going to go on to step 4. So after we've created that chain of title, we need to write down the document references. So the documents annotated, and we write down the results from the search in a clear and understandable order and in terms. Sometimes you can do that in conjunction with step 3 and doing that. But it may be simple as just a list of the documents found in the order that they're recorded. So sometimes the chain is written with oldest to newest, and sometimes it's the other way around where it's the newest to oldest, and it's often due to a preference of the searcher, but sometimes it's out of necessity based on the information you have to start with and your goal and what you want to accomplish with it, with that step. But either one, whether it's written front to back or back to front, it's still an acceptable search. You can still follow that chain. So as we do in the homework and in the test, whichever way you do it, it's acceptable as long as you can follow it and you can show someone and they can follow that chain as well. Step 5 is to examine the documents. So once you've got your list of documents and the ones you need to look at, each document that's discovered and annotated in the search really should be examined, and even they must be examined to make sure that they meet the lawful purpose for which they were intended. Make sure that everything is there. Make sure it conforms to the laws, and that they were executed properly. Excuse me. Ask yourself, was it properly executed? Was it acknowledged and notarized? Does the property convey interest in the title that we expected, or is it something less? So that's an important part, to make sure as you're doing your research that all of those documents actually do apply, that they do accomplish what we expect them to accomplish. So for the purpose of our homework that we do, and for the test, we're not going to do step 5. We're not going to examine the documents, and most of that is because of the practical. There's no real practical way to do that. The chain of title for the homework comes out of Davis County, and then the test will be from the Box Elder County records. But to have copies of each of those documents is just not a practical way to get you that information. So we're not going to do that. But I think it's really important, as you're doing the searches in your own county, that you go and find those, track them down, look at the actual document, make sure that the description in the index actually matches what the actual document says, because the document is the information that actually conveyed the title, or actually did created the easement, or actually did what it is you're trying to find. So that it's a very important step, and just because we don't talk about it in these classes, or we don't do those steps, I think it's still a very important step to do that. So an important note, that the act of recording in the recorder's office for the purpose of giving public notice of an action does not automatically accord a valid or effective transfer of the document stated purpose. Okay, so just because it's recorded doesn't mean it's a valid transfer. Also, if a document is not recorded in the county recorder's office in the course of the transaction, the omission of that recording does not invalidate or nullify the transaction. It merely omits the public notice in the recorder's office that such a transaction transpired. Some of those things we'll talk in a few minutes, maybe court documents or other things. But in addition to that, there are some lawful presumptions regarding title to real property that are allowed by the statute in the state code, because they otherwise duly recorded documents, and the searcher should acquaint themselves with those presumptions. Because of that, I recommend you you go and see what those presumptions and what's allowed by law. It's not going to be part of the test, but it's really good information, and that comes from the Utah Code 57-4A-4. So that brings us to our last step, step 6, which is to summarize the results. So we summarize and determine the net results of the search. Does it meet our expectation? Does it resolve our questions or dispute? Does it help us answer our questions, or does it clarify the issue? Did we meet the goals that we set up in the first few steps? Did our search actually meet those goals and help us accomplish what we were looking for? That's really important for a cadastral mapper, is those things. Did we clarify the title? Did we find the gap in the chain or help us understand better? Which is a little different than a title company, because at this point, a title insurance professional would produce a written title report or a preliminary report. Sometimes it's called a commitment binder or other things, but that report is to prepare for an escrow officer to help for the closing of the sale of the property or refinance of the property. But our goal is really just to find and clarify any questions or clarify the title for taxation or boundary adjustment purposes. So those are the 6 steps. Some of them are longer than others. I think they're all important, but to sum everything up, after we have thoroughly examined the documents, the searcher should be able to tell or ascertain the current legal description that's of the record, its bounds, its boundaries, the area. You should be able to know the current owner of record, and also be able to tell if there's any other encumbrances on the property that it would affect the boundary. That would include overlaps or gaps, sometimes called underlaps, but those should all be evident based on the search and made very apparent through that search. One other thing to note is that we talked a little bit about documents that might not show up in the records at the county recorder's office. And the searcher needs to be aware that there might be judgments or other documents that could affect the ownership or things, and those might be filed in various courts or other jurisdictions that may appear that may have that impact on the ownership of the property. And so a good title searcher would need to pursue the name search in those locations to be able to identify if there are any of those encumbrances or judgments or other things that might affect the property records. So that brings us to the last of it. The next thing to talk a little bit about, we've talked all about how to do that, is to talk about the homework. The homework is basically designed to help you do 2 things: to prepare for the test and to prepare to be able to do these things in your office, and answer your own questions and do those things. So this homework, for this, we're actually going to do some searching out of the Davis County records. We've got copies of those. They should be on the web page attached to the homework, where you can download them. If you've downloaded the entire manual, it's also in your manual. But we're gonna go through the Holmes Creek subdivision. That's part of the northwest corner of Section 27, Township 4 North, Range 1 West, Salt Lake Basin Meridian. So as we go through that, we've got a lot of resources that are attached to your homework. There's the Holmes Creek subdivision plat, the ownership plat. There's a bunch of abstract pages. Those go through the section abstracts. It also has the subdivision abstract. It goes back to the handwritten ones, and it also, for the purpose of the exercise, the first couple of steps we talk about what we want to accomplish. The basic thing that we want to accomplish is to be able, for this homework, is to be able to answer the questions. Some of those questions you'll be able to answer using some of the resources without doing a title search. That's just like in real life. You may be able to answer some of those questions without doing a huge title search. You can just use some of the other available resources. But there are some questions on the homework that you'll need to do the title search for that. If you've got questions on how to do that, the homework is the time to answer those questions. Make sure you thoroughly know how to do that, because you can ask for help on the homework, but you won't be able to ask for help during the test. So make sure you understand this. It's going to be a different search, but it's very similar. All the principles are the same. We'll go over the homework when we meet together for our conference call and web demonstration. I'll have all the answers ready for you. If you've got questions, we can go over those and help you with anything you need. So download the homework, and that's it. One thing I want to recognize is I want to thank Davis County for their help in preparing this first part of the cadastral mapping. They gathered a lot of the information for this practical exercise. They gathered a lot of the code, and Richard Mon and Lael there from Davis County put a lot of work into helping get this information going, and I appreciate their efforts, what they do. So I just wanted to thank them. So for those of you that are ending with just part one, it's been a pleasure. Those of you that are going on to part two to be a full certified cadastral mapper, we'll meet again coming up at our scheduled time, so you'll be able to go through those chapters and do that. Thanks a lot. Let me know if you have any questions.